Now in session. The first matter that we have on the docket today is C200032 Par versus Geico Insurance et al. Good morning, Mr. Frank.
Good morning, Your Honor.
Mr. Garvey, I understand that you all are in the same, so I just want to make sure everybody, you both.
Yes, Your Honor.
Great, thank you. Mr. Frank, obviously, sir, you understand you have 15 minutes this morning. Did you wish to reserve some time in rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes.
All right. Obviously, we don't have buttons here. If you start getting close to your time, I'll kind of interrupt you, okay?
Certainly.
All right. When you're ready, sir.
Yes, Your Honor. Your Honors, may it please the court. This case involves a application of Kentucky law to a uninsured motor vehicle coverage provisions in a Geico policy. The date of the injury is 7/25 of 17. Mr. Leanne was a 28-year-old married individual with 3 young kids. He was leaving work as a sushi chef for Fresh Market and was driving home when this incident occurred. There is no dispute that he was driving an insured vehicle at the time. There is no dispute that the bullet or the bullet that killed him came from another car. We're here to respectfully request that this court reverse the trial court's decision to grant summary judgment in favor of Geico and enter summary judgment in favor of the plaintiff appellants.
Well, but how do you get around the Smith case from the Kentucky Supreme Court? Because that involved an almost identical situation where a driver was shot while driving, and the Kentucky Supreme Court said that doesn't arise out of a motor vehicle accident.
That was 1985-86 law, Your Honor. There's been no cites since then of that case. The law that we have cited, Stamper, Peacock, and Hall, and Stamper and Peacock are Court of Appeals opinions, are directly opposed or contradictory to that finding.
Well, but our job is to apply Kentucky law as explained by the Kentucky Supreme Court. So what do we do if we find these Court of Appeals decisions to be in tension with the Kentucky Supreme Court?
Well, Your Honor, to be honest with you, all I can tell you is that we've submitted the most recent law that addresses these particular issues. If you find that the Stamper decision is controlling, then I still think that even under that decision, we should be entitled to PIP benefits. Not only were we denied uninsured motorist coverage in this case, but we were also denied personal injury protection benefits. But I would suggest that the Court of Appeals in both Stamper and Peacock were well aware, and the Hall were well aware of the Smith decision. And I don't see any difference between the Peacock, in Peacock and in Stamper, there were assaults, criminal assaults by assailants. Now, in this case, with our client, there is absolutely no evidence that this was an intentional act, okay? Smith was an intentional shooting.
Well, Mr. Frank, let me ask this question. So when I read Hall, they talk about a pure unintentional accident. And so what we're really discussing is foreseeability, right? And the question is foreseeability. And is that a legal question to be determined, or is that a question of fact for a jury to determine?
Well, I would suggest it's a question of fact, Your Honor. But I did want to finish up in addressing Your Honor's previous question, in that in this case, remember, there is no evidence as to how this bullet actually was discharged from a firearm other than it was from a moving vehicle.
But does that matter to your analysis at the end of the day? Like if the evidence was that the shooter was intentionally targeting the driver of the other car, is there a difference between that and he's cleaning his gun in a car and the bullet accidentally discharges and hits the driver? Is there a distinction there?
Well, I do think there's a distinction there, but I think there's further evidence. What if the gun was simply on the dashboard and the car hit a bump and the gun discharged?
Well, that's what I'm asking though, is what role does intentionality play under your view of Kentucky law?
Well, first of all, I would say two things, Your Honor. I'd say, first of all, there is no proof of intent here at all. Second of all, I'd say even if there was proof of intent under the law we've cited, and I can specifically quote Stamper, intent is the intent in the mind of the insured at the time of the injury should determine whether the acts are accidental or intentional. And in this case, there's no argument that our intended or had anything to do with a bullet coming through the window and killing him. So
that goes back to my question. The person mowing the lawn that the rock flew out and hit Miss Hall in the eye and injured her. Obviously, the person mowing the lawn wasn't intentionally trying to do that. And to your point, it's the same thing. Whether or not the person was intentionally fired the weapon or was accidentally discharged, it doesn't matter. It goes to the foreseeability issue and whether it was an intentional or unintentional action anyway. So that goes back to my question. If you want to, how is this foreseeable?
How is the incident foreseeable?
Well, again, going back to basic tort law, I mean, there obviously was a superseding event with the gun being discharged, which has to be in somewhat foreseeable. How is that foreseeable in this case? How do you get around the basic concept of the tort?
Well, it would be negligent if somebody, a firearm was discharged while they were driving an automobile. That would be negligent. And is it foreseeable to have a loaded gun to be discharged in a moving vehicle? I would say yes, but I don't think that in this case, all we have to show is that our client was using a motor vehicle for an intended purpose, which he was driving home from work, and that an uninsured driver caused the injury, which they agree is a bodily injury, and that whether it's accidental or intentional is taken from the perspective of the injured party. So under the circumstances, we would say whether it's intentional, unintentional, under Kentucky law via Stamper, Peacock, and Hall, this incident should be covered. They're not arguing that there was no bodily injury. They're not arguing there was no coverage. They can't argue that it was intentional.
Having a hard time understanding how the shooting actually, how you could say the shooting arose out of the use of the vehicle. I understand the shooting, the gun was fired from a vehicle, but how does it arise from the use of a vehicle?
Well, it arises, Your Honor, from the use of a vehicle, because if it wasn't in the vehicle, the injury wouldn't have occurred. And when we say fired, we're again assuming that somebody was actually pointing or targeting the decedent herein. There's no evidence of road rage. There's no evidence of targeting. There's no evidence at all. The police report that opposing counsel points to says investigation pending. They haven't identified the car. They haven't identified the driver. They haven't identified how this incident occurred. The only thing that's been stipulated jointly based on the police report is that the bullet came from a moving vehicle. And guns are transported in vehicles routinely. So again, to your point, Your Honor, foreseeability, a discharge of a gun accidentally in a vehicle is extremely foreseeable, whether by intention on cleaning a gun or otherwise. The vehicle itself could have discharged the gun if it was loaded and sitting on the dashboard and it hit a bump. The vehicle itself would have been the absolute cause of the injury in this case. And insurance policies, as this court knows, in Ohio and in Kentucky, have to be liberally construed in favor of the insured. And there's nothing in this policy under the law of Stamper Peacock Hall that would not allow this to be covered.
If you want to reserve the rest of your rebuttal time. Thank you.
I would, Your Honor.
I thank you.
Thank you.
Mr. Garvey.
May it please the court. Good morning.
Morning.
The crux of the case is, as has been asked, the arising out of the use of language and Kentucky's general public policy. So we have basically 3 lines of cases cited in the briefs. The oldest ones from the 70s really deal with liability policies. And you see how the courts interpret arising out of the use of those in certain fact situations. And then the cases, particularly the 86 case, the last time the Kentucky Supreme Court has spoken definitively on both an arising out of the use of situation and a firearm situation, whether intentional or unintentional. Those are PIP cases or no fault cases. And then the cases, the Stamper case from 2011 is a UM case, right? And in this appeal, we have 2 issues. We have, does this policy cover no fault benefits for the policyholders? Does it cover uninsured benefits for the policyholders? And so at no time has the Kentucky Supreme Court or even the appellate courts in Kentucky stood for the proposition that intentional or unintentional discharge of a firearm is covered under either no fault or because the discharge of a firearm does not arise out of the use of a motor vehicle. It's
well, what about the decision in Hall where they give they go through these hypotheticals of, you know, a kid throwing a rock off of an overpass? I mean, that clearly would be an intentional act, and it would not really arise out of the use of a motor vehicle because the kid's not in a car. But even then, and albeit it was dicta, but the Kentucky Court of Appeals suggested that that would be sufficient. So how do you respond to that?
Right, and in looking at the analysis, what I see in Hall is really a 2-step process. Not only would the accidental injury occurring out of the use of the vehicle, they said the rock thrown from the mower, a rock slide from a hill, a bird striking window, that court said that all those would be accidental injuries occurring out of the use of the vehicle. That is the normal contemplated use of a motor vehicle. But then it goes on to say, and causally related to the use of the vehicle. In other words, there's some connection, more than just an incidental one, like a gun being fired. There's some connection to the normal use of a motor vehicle. So I think Hall is an important case because while it is a PIP case, that is, it's a no fault case, it looked at the statutory scheme in Kentucky that said, look, we want to get benefits to people regardless of fault. And so, but it still required that the claimant prove that the loss or injury arose out of the maintenance or use of a motor vehicle.
Well, yeah, but go back to my question about the rock thrown from the overpass. How does that arise out of the use of the vehicle under your theory of the case?
It's, it's a great question, Judge. When you look at the one person dissent in a later case that looks at Hall, it says, why did the court shift from a positional, from a causal to a positional view? All I could say is Hall found significant differences between the specific fact pattern in Smith involving the use of the gun. The Hall court said Hall was using a motor vehicle, and unlike Raines and Smith, who were injured by intentional acts, her injury resulted from a pure unintentional accident. So we'd be guessing, but I think Your Honor has caught on to something. In the scenario where it was proven that a child intentionally threw, say, a rock over an overpass that hit the vehicle, and that was not a pure unintentional accident, but was an intentional incident. It's be interesting to see what a court in Kentucky would do with that. I could see that potentially going either way, but it's still not one of those ordinary foreseeable actions or incidents causally related to the use of a vehicle. And it's really these, Hall stood for the proposition, again, this is years before Stamper, where they kind of took away the intentional act and said an accident is whether it was intended or not intended. But if we were just following Hall, it would say two steps. Hall needed an accidental injury and cause related to the use of the vehicle. So if it were just Hall and a kid threw a rock.
Do you agree that this is an accidental injury in this case?
It could be either or. The record below suggests that while it's an investigation for a murder, it's not known.
Well, I'm not saying intentional or unintentional. I'm saying accidental, because as I read the Kentucky case law, they say accident is determined from the vantage point of the insured. Was this something the insured was intending or expecting?
Right, and I think for purposes of this case, we have to just accept that irrespective of whether it was an intended or an accidental shooting by firearm, that if it arose out of the use of the motor vehicle, in general terms, but when you look at the Geico policy, and the injury was caused by that vehicle, not by that gun, but that vehicle, then it doesn't matter, right? It could be either intended or accidental, but and that only gets the claimant to one step toward what they need to do. The policy, Kentucky has, obviously a scheme that says insurers can offer this, insureds can reject this coverage. It's not mandatory, but it was offered in this case. And so it's a contract case. We look at the policy, and the policy clearly says that it would cover bodily injury caused. But in this policy, which is, drafted decades after these earlier decisions, the loss
let's look at that language, because it says caused by an accident arising out of the operation, maintenance, or use of a motor vehicle as a vehicle. And so it's framed in kind of passive voice. And so I can read that little phrase there and say, well, the decedent here was operating the motor vehicle as a motor vehicle and was using it as a motor vehicle, and there was an accident that caused during his use and operation of the motor vehicle. So why isn't that enough to answer the question?
Well, I think Your Honor may have quoted from the PIP section of the policy, which is fine, and I'll answer that question. That tracks the KMVRA, the no fault statute in Kentucky, that provides for insurers shall pay no fault benefits for loss from injury arising out of the maintenance or use of a motor vehicle. So the policy tracks that as it should. That's a mandatory offer in Kentucky. And so, but when you go and look at the cases in Kentucky from the 70s and 80s, even Hall, which is a 91 case, that interprets this arising out of the maintenance or use of a motor vehicle, it goes to the ALR, it goes to Appleman on insurance, And it looks at those things and says it has to be causally related. So what's missing here is the cause. It's the gunshot is incidental to the use of a motor vehicle. It's certainly not caused by a motor vehicle accident. It's not caused by either the claimant's motor vehicle or the hit and run or the uninsured motor vehicle. The, deep and long in Kentucky law and in these sort of historic sources, ALR and Appleman on insurance, is this thread that forms the basis of interpreting the arising out of the use of. And so no case in Kentucky has ever found that a case involving either accidental or intentional discharge of a firearm is close enough or creates that causal relationship. If we were to look, Your Honor, at the language for uninsured, it's very similar to the no fault. That's on page 10 of 18 of the GEICO policy. They will pay damages for bodily injury caused by accident. And in this case, we have to assume it doesn't matter whether it was intentional or unintentional because of the way Stamper interpreted its holding. So we're not arguing over accident. It's the insured is legally entitled to recover from the owner or operator of an uninsured auto or hit and run auto, and again, arising out of the ownership, maintenance, or use of that auto. So here GEICO's policy is tighter or even more narrowly drawn than you could say what we can divine from the policies that were reviewed in Stamper, even Peacock, and even Hall. That policy and the holdings and the dicta in these other cases that are cited in the briefs support this, is that insurers are allowed to make appropriate restrictions in their contract language. So this GEICO contract that you're interpreting, you're trying to say, would a Kentucky court extend where it never has before coverage for injury by gunshot? It doesn't even fall all four square on the facts of the language of the policy or use of that auto. And that auto refers to the tortfeasor's auto. Now, there's no evidence in this record that there was an injury caused by an automobile. So we just can't flip it and say, well, a gun from an automobile, that's never been approved or supported in any way in any of the cases that we've seen.
So talk about the hypothetical that your opponent offered about you've got a gun on a dashboard, you go over a bump and it discharges. How would you analyze that?
Well, I would go back to the 1970 case, the first of the 1970 cases. I had it here. Apologize. In that case, and so it says that case was decided by the Court of Appeals of Kentucky. So, but that was a Kentucky Supreme Court case. In 1975, the legislature created what we now know as the Kentucky Supreme Court. Before 75, the Court of Appeals was the highest court in Kentucky. So here in this 1970 decision, it says from the Court of Appeals, U.S. F&G versus Western Fire, that is the Kentucky Supreme Court decision, if you will. Now, this also predates the creation of the no-fault scheme that happened in 75. But this was between two indemnity. This was, what does a liability policy say when it comes to arising out of the use of? And here the fact pattern is the accidental discharge of a firearm by a fellow passenger. That court, interpreting the same language this court is essentially diving into, says that does not arise out of the use of an automobile within the meaning of the insurance policy. So in an indemnity policy or a liability policy from 1970, the court, going back to the same ALR and the same Appleman, the things that kind of flow through all these decisions, looked at this fact pattern and said it doesn't qualify. And why did it do that? It says, quoting Appleman, it says the accident must have arisen out of, quote, the inherent nature of the automobile as such, close quote, in order to bring it within the terms of the use clause. So, 50 years ago, there had to be a connection, a nexus, and it was tied to the automobile. It wasn't tied to, so in that case, it basically said even the accidental discharge of a firearm in the car that struck another passenger, that they said wasn't related to, being bounced on the road or anything like that. It found no coverage for that scenario. And then you move forward 15, 16 years to Smith, you actually have a very similar fact pattern to a shooting, 2 shootings, and that court said in no way were no fault benefits required to be paid, because that clearly didn't arise out of the use. So you overlay Stamper on top of that, and you say, well, it doesn't matter if it was intentional or unintentional. Smith would still say that's no way related to the use.
So just a quick question on that. So if the person who did the shooting, if somehow you could figure out that a bump caused them to pull the trigger, a bump that the automobile hit, would that arise from the use of an automobile?
It's a great question. This record's silent on that point, but so we could play and go down that route. And I have no problem with the court doing it, because we would say, okay, so what do we have? If we could actually prove that the automobile caused the accidental discharge of a firearm, would that arise out of the use? I submit, with respect, based on what we see, Kentucky is sort of known for having, just compared to Ohio, far less decisional places to go. So like Ohio might have 50 decisions or 100 decisions on this. Kentucky might have 3. It's not a criticism, it's just an is. But but on this case law and what we see in the cases where the court would get hung up, I respectfully submit, is it would say, but even then, how does that arise out of the use of the motor vehicle? It's possible. I have to concede, it's possible a court could say on proven facts that a gun just sitting there on the dashboard malfunctioned in some way because the car hit a bump and that set off the firearm and then caused an injury. I think it is certainly possible to think a Kentucky court might connect that, except in general terms, based on what we see in the case law. But then it would go to the Geico policy. It would say, but it has to be from the use of that auto. Geico's policy is more restrictive. It says the injury must be caused by the automobile. I think it's why you see a very clear line in the gunshot cases, no coverage. The intentional or unintentional cases where the car does something, there's clearly coverage. So
injury doesn't have to be caused by the automobile, right? It has to just be caused by the use of the automobile.
That's correct, but it has to be more than incidental. And gun cases have always been seen as incidental, but these other fact patterns, because they are more tied to the ordinary foreseeable use of the motor vehicle, they've been found to allow coverage. So I think you've picked up exactly the distinction that applies.
All right, thank you, Mr. Garvey.
Thank you, Your Honor.
Mr. Frank, you still have your rebuttal time, sir.
Thank you, Your Honors. I'll be very brief. I'd like to refer the court to page 10 of our brief. Mr. Garvey's talking about cases from 1970s, Smith from the mid-80s. He's talking about cases that are from 50 years ago. If you read the Stamper Court explains specifically the words arising out of the use in an automobile liability insurance policy are broad, general, and comprehensive terms, meaning originating from or having its origin in, going out of, or flowing from. There's no question in this case that the bullet that struck and killed the decedent came out of, was flowing from, or had its origin in a vehicle. When he talks about Hall being causally, when you look at Hall, Hall had nothing to do with another vehicle. There was no hitting. There was no, it was a lawnmower and a rock. It had nothing to do with a different vehicle. In this case, the gun or the bullet is stipulated to have come from another vehicle, going out of, flowing from. That's the causal relationship. And it's specifically set forth in Stamper, which is a 2011 decision explaining Kentucky law relative to arising out of the use of. And what Mr. Garvey, and eloquently, though he's trying, is he's trying to make this a hit and run situation and not an uninsured motor vehicle situation. In a hit and run in Kentucky, there has to be a vehicle hitting the other vehicle, and then the individual has to have independent corroborating evidence. That's not the case in this situation. And if the court doesn't have any other questions, that's all I have.
All right. All right. Thank you very much for your arguments. The case is now submitted. Thank you.
Thank you. Thank you.
All right, then we'll move on to the next case, which is C20075 through 78 in Ray JM.
May we be excused, Your Honor, from the
Yes,
first?
thank you. Thank you, counsel.
Thank you, Your Honor.
All right, good morning, Ms. Christopher, Mr. Heenan. Ms. Christopher, you have 15 minutes this morning. Did you wish to reserve some time in rebuttal?
Yes, Your Honor, just 3 minutes, please.
3 minutes, okay. I will keep your time. I'm just curious though, from my reading of the briefs, I think, Mr. Heenan, that the state has sort of conceded this error. Is there something else that needs to be addressed this morning?
Oh, no, Your Honor, I just wanted to make sure that I clarified just a couple of things for the court, mostly that this case is in alignment with the EB case out of this from this court, and that I just wanted to be very clear that JM was adjudicated only of complicity to commit aggravated robbery, and the state stipulated and the court acknowledged that she had never, she was not involved with the use of the firearm. She did not furnish, use, or dispose of any firearm involved in the offense. So at this point, she would only be eligible to receive at the most a 1-year gun specification, not the 3-year gun specification that the court imposed at the time. So I just really wanted to clarify that for the court and make sure the court didn't have any questions.
Okay. I don't think we have any questions. Mr. Heenan?
I already said she won, so unless you got any questions for me, seems pretty easy.
I think she's waiting for you to say uncle and maybe a written apology. No, I'm kidding.
I've got
You don't get those. All right. Anything else, counsel? Anyone else wants to put on the record this morning?
No, Your Honor, that was all.
All right. Well, thank you. Case is now submitted. We will review the record and issue a timely decision.
Okay, thank you.
Thank you. All right. Have a nice day.
You too.
Thank you.